fascinating issue about marijuana in the workplace. Because we're lawyers, we have to start off by making sure that everyone understands that this webinar is to provide information and not legal advice. If you have a specific issue, please consult your attorney. Marijuana in the workplace is a really timely, interesting, and confusing topic right now. So our goals for today are to discuss the changing laws regarding the use of marijuana, to help you understand the laws that employers must be mindful of when addressing applicants' and employees' use of marijuana, and to provide best practices for dealing with this emerging issue in the workplace. To give you some background, over the past decade, there have been a multitude of state laws dealing with marijuana. So at this point, 29 states and the District of Columbia have legalized the possession and use of marijuana for medical purposes, while another 17 states have legalized the medical use of cannabinoid extracts. 9 states and the District of Columbia have also legalized limited amounts of marijuana for recreational purposes, and 22 states have decriminalized possession of small amounts of marijuana. And what does all of this mean for your workplace? And what kind of impact does it have on your drug testing policy? Well, we're going to start off with a quick review of some of the employment laws that intersect with marijuana use by applicants and employees. So first, employment at will. In every state except Montana, which requires a termination for cause, employment at will is the rule. This means that either the employer or the employee can terminate the employment relationship at any time, with or without cause or notice. The one caveat is that you cannot terminate for an illegal reason, like discrimination on the basis of some legally protected characteristic, like race, sex, religion, or disability, or because someone exercises rights that are protected under the law, like taking family and medical leave or serving on a jury, or if that person acts as a whistleblower to report illegal activity. Next, we're going to talk about the Americans with Disabilities Act. It's another law that we have to consider in this context. Under the ADA, employers cannot discriminate against qualified individuals with disabilities in job application procedures, hiring, firing, and the other terms and conditions of employment. And why is this an issue? Well, because the use of medical marijuana has to be tied to a specific medical condition by a doctor. And anyone suffering from a condition for which they can use medical marijuana is really likely going to be considered disabled within the meaning of the ADA. I also want to mention that many state disability laws mirror the ADA, so they would also be protected under those state disability laws. And under both the ADA and the state disability laws, there is a duty to accommodate. So an employer is required to make a reasonable accommodation to the known disability of a qualified applicant or employee, as long as it doesn't impose an undue hardship on the operation of the business. But you are not required to excuse an employee from performing their essential job functions. Now, an employee who is disabled cannot pose a direct threat to the health or safety of themselves or others, meaning visitors, clients, coworkers, vendors, patients, anybody else in the workplace. What does it mean to be a direct threat? It means that there is a significant risk of substantial harm. It has to be based on valid medical analyses or other objective evidence, and a slightly increased risk of harm is not enough. Also, it has to be a current specific risk, not a remote or speculative one. So a fear of future injury, a fear that somebody is going to be absent in the future, or that they're going to file a workers' compensation claim, or that they're going to increase your insurance costs. Those kinds of fears are speculative, and they would not be a basis for considering an employee to be a direct threat. And then you also have to think about whether or not that risk can be reduced by a reasonable accommodation. The next set of laws I want to talk about are legal off-duty conduct statutes. Many states have lawful products or lawful activity statutes that protect employees' rights to engage in the use or non-use of a lawful product, such as tobacco or alcohol, or to participate in lawful activities away from the workplace during non-working hours. Employers can't discipline or terminate employees for engaging in these activities, even if they think there will be harm to the company's reputation or the company's business opportunities. And some other common law concepts. The first is wrongful termination or wrongful discharge in violation of public policy. And the basis for this claim is that the discharge must violate some clear mandate of public policy. And courts look to other court opinions and statutes or regulations for clear mandates of public policy. So in this case, is legalization of marijuana for medical or recreational use of public policy? It could be for that particular state if the state has passed a law that legalizes the use of marijuana. But the public policy that supports use of marijuana might be very specific to particular types of use, not just use generally. The other concept I wanted to mention was negligent hiring or retention. And this involves a situation where an employee causes an injury to somebody, and that person then claims the employer was negligent in hiring or retaining that employee. So if an employee was high and hurt a customer, the employer could be held responsible for the employee's conduct if it knew that the employee was using marijuana. Now I'm going to turn it over to Parker to discuss laws specifically dealing with marijuana.
Thanks, Fiona. So what we'll start with is a discussion of the federal perspective on marijuana laws. And there's been a recent shift in the new administration, but under the Obama administration, as Fiona mentioned, over the course of the last decade, numerous medical marijuana and other marijuana legalization and decriminalization laws were passed in a variety of states. And the Obama administration, through the Department of Justice, took a hands-off approach in memoranda signed by members of the Department of Justice. They indicated that they would not focus federal resources in states with legalized marijuana when the individual's actions are in clear and unambiguous compliance with existing state laws providing for the medical use of marijuana. So as long as individuals or organizations were in compliance with the state law permitting marijuana use or distribution or cultivation, the Department of Justice exercised its discretion to let those actors continue rather than to enforce the federal law prohibiting marijuana use or possession. Now, under the Trump administration, there's been a very recent shift in perspective and enforcement guidance. On January 4th, 2018, Attorney General Sessions rescinded these Obama-era memos that had adopted the policy of non-interference with marijuana-friendly state laws. And the memo specifically stated that given the department's well-established general principles, previous nationwide guidance specific to marijuana enforcement is unnecessary and is rescinded effective immediately. So this is a big shift in which the Department of Justice decided that it would not take a hands-off approach in states that had marijuana laws. Previously, Attorney General Sessions has stated it is my view that the use of marijuana is detrimental and we should not give encouragement in any way to it, and it represents a federal violation which is in the law and is subject to being enforced. So clearly a very different outlook and a different approach from the Department of Justice currently than under the Obama administration. The federal law to which those memos referred, both under the Obama and Trump administrations, is the Controlled Substances Act of 1970. Marijuana is illegal under that federal law and is listed as a Schedule I drug, or the most dangerous types of drugs, which include other drugs like LSD and heroin. Another federal law that's important for us to consider in this context is the Drug-Free Workplace Act of 1970. The Drug-Free Workplace Act requires any organization that receives a federal contract of at least $100,000 or federal grants to establish a drug-free workplace. However, it does not require employers to drug test employees. One important caveat here is that this does not apply to healthcare providers solely by virtue of Medicare reimbursement, which does not constitute a grant or a contract in excess of $100,000. In addition to the Drug-Free Workplace Act, federal regulations from the Department of Transportation still prohibit use and require regular testing for safety-sensitive employees in the transportation sector. And you can see listed here a number of different types of positions that are subject to these regulations. These regulations also touch on the requirements for returning an employee to work after a failed drug test. So what does all this mean for employers when considering the federal laws governing marijuana? Marijuana remains an illegal drug under federal law, and the cultivation, distribution, possession, and use are criminal acts under federal law. And as we can see from the recent Attorney General Sessions memo, the Department of Justice will be enforcing the federal law rather than taking that hands-off approach, which has been the approach until just a couple of weeks ago. With that, I'm going to turn it over to Fiona to talk some about the state laws that come into play.
So there are a number of state laws that deal with marijuana, as we've already discussed, and these include decriminalization, recreational use, and medical use. So which states have decriminalized marijuana? There are 22 of them that are listed here, but what does that actually mean? And well, Parker, I will say that my teenagers were tremendously excited to hear that Maryland had decriminalized marijuana when that happened a few years back, and they were really, really sad to hear that it didn't actually mean that marijuana was legal. So it's just become a civil offense instead of a criminal one. So that means that there won't be an arrest, prison time, or a criminal record for the first time possession of a small amount of marijuana for personal consumption, and it's similar to a traffic offense. The next group of laws that I want to talk about are recreational use laws. And 9 states, the ones that are listed here, have legalized recreational use, and other states are considering it. Maine passed it pretty recently, but they have not yet implemented it. But there's been a lot of press about recreational marijuana going on sale in California at the beginning of the year. And then Attorney General Sessions came out with the DOJ's new and aggressive enforcement position that you discussed, Parker, earlier, and that's really thrown a wrench into the status of these laws. So what do these laws do? They legalize the personal use of marijuana, and they specifically permit possession of small amounts of marijuana for personal use, and then they also permit the cultivation of a limited number of plants. But as Attorney General Sessions noted, it's still illegal under federal law, and individuals and marijuana-related businesses can be prosecuted for violating the law. Now, as I mentioned earlier, there are some statutes that protect employees' ability to engage in general legal off-duty conduct, and some other states protect the employee's use of lawful products. These states, some of these statutes actually define lawful products as specifically tobacco and alcohol, and so those particular statutes are not going to apply to marijuana. But some states don't have a definition, so arguably lawful marijuana would be covered. But so far, these legal off-duty conduct laws don't have any effect. So specifically in California, the recreational use law allows, quote, public and private employers to enact and enforce workplace policies pertaining to marijuana without limitation. So employers can take any kind of workplace position that they want with regard to the use of marijuana, including the off-duty use of marijuana. And in Colorado, which has a lawful off-duty conduct law, there is a case, Coates versus Dish Network. In that case, an employee was a medical marijuana user, and he was terminated after testing positive for marijuana. He then sued, claiming that his marijuana use was legal under this lawful off-duty conduct law, and Colorado law therefore protected him. But the Colorado Supreme Court said the activity has to be lawful under both state and federal law, not just state law. And since marijuana is illegal under federal law, it wasn't lawful, and the off-duty conduct law didn't protect the employee. So his termination was perfectly appropriate in that case. The other states with such off-duty conduct or lawful product statutes haven't explored the intersection of these laws with the laws legalizing the use of marijuana, but generally speaking, we'd expect those courts to follow the lead of the Coates versus Dish Network case, because marijuana is still illegal under federal law. But we're not going to guarantee that, however, because the courts often change their minds. Now, the last group of laws that we wanted to talk about was the medical marijuana laws. So a majority of states, which are listed here, have legalized the use of medical marijuana or medical marijuana extracts. And generally what these laws do is they remove criminal sanctions for the use and possession for medical purposes, and they provide means of access through dispensaries or by permitting home cultivation or both. Now, these statutes typically contain a list of illnesses or diseases for which medical marijuana can be used. So it's not just any illness, it has to be one of these very specifically listed illnesses. And it also has to be certified as necessary by a doctor. So if I have the flu or if I have an anxiety disorder and I feel like marijuana would help me, I can't just smoke it and expect to be protected under these laws. So here is the key takeaway at the moment under medical marijuana laws. Employers are not required to allow the use of marijuana on an employer's premises, and employers are not required to permit employees to work while they are impaired or while they're under the influence of marijuana. But Parker's going to talk more specifically about what employees using medical marijuana are entitled to with regard to the laws that are out there.
Thanks, Fiona. So the first question that we want to answer is whether there's an obligation to provide accommodations under federal law. So as Fiona discussed, the federal law that governs discrimination against individuals with disabilities is the ADA. And the impact of that law on marijuana use was explored in the Ninth Circuit case of James v. Costa Mesa. And the determination ultimately was that there was not an obligation imposed under federal law. So a couple of points of background with respect to the ADA on this case that are important. The ADA excludes from its definition of qualified individual with a disability individuals that are engaged in the illegal use of drugs when the employer acts on the basis of such drug use. The ADA then goes on to define the illegal use of drugs as the use of drugs, the possession or distribution of which is unlawful under the Controlled Substances Act, but such term does not include the use of a drug taken under the supervision by a licensed healthcare professional or other uses authorized by the Controlled Substances Act or other provisions of federal law. So the court analyzed this provision. The plaintiff in that case, the employee who'd been discharged, argued that because the marijuana was being used under the supervision of a licensed healthcare professional, that it was not to be considered the illegal use of drugs under the Americans with Disabilities Act. The court rejected that notion and read the ADA to require or to include under illegal use of drugs the use of marijuana because it is prohibited by the Controlled Substances Act, saying that the use under supervision by a licensed healthcare professional alone did not make it lawful under federal law, and that it was therefore still considered the illegal use of drugs under the ADA. The argument that the employee put forth may have been analyzed differently by the court had the employee focused on the underlying disability rather than the use of marijuana in this particular definition under the ADA. We'll explore that a little bit more later in the presentation. So what about state laws governing marijuana specifically? The state laws fall into four different categories. The first, requiring accommodations. The second, silence on accommodations but allowing employers to implement workplace rules regarding drug use. The third, accommodations for workplace use specifically not required. And then the fourth, silence on both accommodations and workplace prohibitions. So in the first category, Nevada stands alone. The Nevada law requires the employer to attempt to make reasonable accommodations for the medical needs of an employee who uses medical marijuana if the employee holds a valid registry identification card. This requirement applies if the reasonable accommodation would not pose a threat of harm or danger to persons or property, or impose an undue hardship, or prohibit the employee from fulfilling any and all of the employee's job responsibilities. The Nevada law does not require employers to allow use in the workplace or modify the job working conditions. Now, you heard Fiona talk about direct threat analysis previously. It's unclear whether the undue hardship exception and threat of harm exceptions under the Nevada law would be interpreted and applied in the same manner consistent with concepts under the ADA. So that remains an open question, but likely it would be analyzed similarly. Next are states that are silent on accommodations. In this second group are those statutes where the accommodation obligation is not addressed, but employers are allowed to prohibit the use of marijuana in the workplace and or allow employers to prohibit employees from being under the influence at work. And I will note here on the slide, the second state there is Arkansas and not Alaska. These laws, as I said, they'll allow the employer to prohibit the use, but otherwise are not addressing accommodations. The next category of state laws are those in which the law expressly sets forth that an employer is not required to accommodate the use or ingestion of marijuana during work hours or on work premises. This group and the second group are somewhat similar in that they both allow employers to prohibit the use of marijuana at the work site, but the statutes in the jurisdictions listed in the second group do not provide any context on employer accommodation obligations. So here we have, in this category here, we have the clear statement that an employer need not accommodate. In the previous, no such statement. I want to mention another subcategory of jurisdictions that specifically address situations in which there would be an undue hardship because allowing an employee to use marijuana would cause the employer to violate federal law. So this is not saying that because the employee is violating federal law by marijuana, they can avoid accommodating the employee, but situations in which employers are put at risk a monetary or licensing related benefit under federal law or regulation. So think of situations in which the Drug-Free Workplace Act that I discussed previously would apply. An employer need not violate that Drug-Free Workplace Act under these particular laws. The final category, sorry, one more, Fiona.
Yeah.
The final category is states that are completely silent on both accommodations and workplace rules. Our home state of Maryland falls into that category. We do not interpret that law as requiring accommodations, nor do we interpret it as prohibiting the discipline of employees for using marijuana. Let's talk some about discrimination claims under state law. Some states' laws expressly prohibit discrimination in employment based upon status as a medical marijuana patient, and some prohibit the denial of any right or privilege because of medical marijuana use. For example, Delaware law allows employers to take action against employees based on impairment on the job, but prohibits discrimination against employees on the basis of the use of medical marijuana. So what this means practically, if you're in one of these states, is that a positive drug test for an employee that shows marijuana use should not result in immediate termination, but instead a discussion with the employee. Florida and Montana specifically state that private suit, meaning that the private suit is not available under the medical marijuana law, meaning that the employee is not entitled to bring a cause of action in court on his or her own. Other states with discrimination language, we would interpret as likely providing for a private suit by an employee. It's important here to note that we're talking here about medical marijuana laws and not the recreational or decriminalization laws. These are particular to the medical use of marijuana. An employee who is using pursuant to a recreational marijuana law is not going to have the same sort of right to a cause of action as someone using pursuant to a medical marijuana law. So I want to talk about what the legal landscape has looked like over the past several years as these state laws have started to come into effect and cases have started to come up into the courts and be confronted by a variety of courts in different states. The first case, Roe, the Washington Supreme Court held that the Washington State Medical Use Marijuana Act did not provide or create a clear public policy that would support a claim for wrongful discharge. So remember, Fiona talked about the concept of wrongful discharge previously, in which a clear public policy needs to be violated by the termination of the employee. Here, the employee sued the employer for wrongful termination, claiming that the employer terminated her in violation of public policy supporting the use of marijuana, medical marijuana. The court emphasized that the statute's narrow purpose in providing a defense to state criminal laws could not support the broad employment protections the employee asserted. So generally speaking, laws decriminalizing marijuana or legalizing marijuana for recreational use are not going to rise to the level of a statement of public policy sufficiently compelling to support a wrongful discharge claim. And the stronger claims will be those brought under medical marijuana statutes that have very strong public policy language in support of their passage. In Ross, the California Supreme Court held that an employee failed to state a cause of action under California's Fair Employment and Housing Act based on the employer's alleged refusal to accommodate his use of marijuana to relieve chronic back pain. In Johnson, the court held that the Montana Medical Marijuana Act does not protect an employee from termination for using marijuana. Additionally, the court found that the employee did not have a claim under the ADA or the state anti-discrimination law. So we're noticing a pattern here. The courts are finding a way to uphold the employer's decision to discharge based on marijuana use. So a few more cases. Washburn, the employee tested positive for marijuana and was discharged, and the case turned on the definition of the disability under the state statute. The court found the employee was not disabled under the state law because it considered mitigating measures. And mitigating measures are things like medications that can alleviate the impact of someone's disability. The employee had claimed that the major life activity that was impacted was sleeping, and the court found that with medication, the employee was able to sleep and thus was not disabled. This is an example of a court that really spent a lot of time on statutory interpretation to come to the conclusion that the employer should be permitted to discharge the employee for marijuana use. In Cassius, an inventory control manager with a medical marijuana card was fired after he tested positive, and the Michigan court held that the state medical marijuana law does not regulate private employment. This is an interesting case because it is, again, an example of a court scrutinizing the statutory language, which pretty clearly seemed to apply to businesses, but interpreted the word business in a very sort of interesting manner that it only applied to state government employment rather than private employment. In Emerald Steel Fabricators, the Oregon Supreme Court held that, consistent with the ADA, employers have no obligation to reasonably accommodate an employee's medical marijuana use under the Oregon anti-discrimination law, and that the employer had no obligation to reasonably accommodate the use of medical marijuana because marijuana was still considered an illegal drug under federal law. And finally, in Garcia, the employer was not required to accommodate marijuana use under the state marijuana law or the state anti-discrimination law. So for a number of cases, the courts have made an effort to find a way to allow the employer to discharge the employee for marijuana use, or in other cases, it was an easy decision for the court under the particular state statute. And this is consistent with the case that Fiona discussed, the Dish Network v. Coast case in Colorado. But I'm going to turn it over to Fiona to talk about some of the recent changes to that legal landscape.
Yeah, it's actually really quite earth-shaking what happened last year, because up until that point, we had been advising our clients that really, if somebody's using marijuana for medical reasons or otherwise, you can terminate them. It's illegal under federal law. No questions asked, end of story. And what happened was the case of Barbuto versus Advantage Sales and Marketing. So this case came out sort of late spring, I think, of 2017. And in 2002, Massachusetts voters had approved a bill permitting medical marijuana. After that, Christina Barbuto was offered a position with Advantage Sales and Marketing, and she was told that she had to take a drug test as a condition of being employed, and she told the company, well, I will test positive for marijuana because I'm taking this for medical reasons under a doctor's supervision. And the supervisor that she was talking to, the hiring supervisor, said, oh, I don't think that'll be a problem, but I'll have to check. And then he went off to Human Resources, talked to Human Resources. She took the test, and after she failed the drug test, she was terminated. And Human Resources told her, we follow federal law, not state law. Well, in this particular case, the Massachusetts Supreme Judicial Court ruled that Ms. Barbuto could pursue claims against Advantage Sales and Marketing on the basis of disability discrimination under the state law because of her medical marijuana use. The court looked to the medical marijuana statute, which forbids the denial of any right or privilege on the basis of medical marijuana use, as Parker mentioned earlier. The court noted that employees or applicants with disabilities have a statutory right or privilege to a reasonable accommodation under the state disability law. And the court then found that the employee would be denied this right or privilege to an accommodation solely based on her medical marijuana use. Now, the employer argued, well, medical marijuana use is not reasonable. It's not a reasonable accommodation because marijuana is illegal under federal law. And up until this point, I think everyone who advises employers would have said, yep, you're right. But the court found that relying on federal law, quote, would not be respectful of the position of state voters that marijuana has an accepted medical use for some patients, unquote. In addition, the court noted that the only person at risk of federal prosecution for the use of marijuana is the employee, not the employer. And therefore, the employer did not have an interest under the federal drug laws. Now, the employer doesn't have to provide a reasonable accommodation that's an undue hardship, and the court in this circumstance recognized that there might be situations involving an undue hardship. So if the employer could prove that medical marijuana use would violate its contractual or statutory obligations, as Parker mentioned earlier. This could jeopardize the company's ability to perform its business. And specifically, the court referenced those DOT regulations that prohibit any DOT-covered safety-sensitive employee from using marijuana. And the court also recognized that federal government contractors are obligated to comply with the Drug-Free Workplace Act. So those employers would be able to claim an undue hardship. And in addition, the court recognized that an employer might be able to show a safety risk to the public, the employee, or her fellow employees from the continued use of medical marijuana or from the potential that marijuana use would impair an employee's work performance. So there's a little bit of wiggle room there for the employer to be able to demonstrate this impact on their business operations. Now, the court didn't explain how the employer would be able to demonstrate this safety risk to the employee, the public, or employee, fellow employees from the use of medical marijuana, but it did allow for that possibility. The court also found that even if the use of medical marijuana were an unreasonable accommodation, the employer should have engaged in the interactive process under the ADA and state disability laws with the individual to determine whether another accommodation, such as other medications, could have provided the employee with an effective accommodation. And I misspoke, it wasn't under the ADA, it was just under state law. So this was the first of the cases, and we all took a step back and thought, oh my goodness, where does this leave us? Well, soon after that case came out, the Rhode Island court jumped into the fray with Callaghan versus Darlington Fabrics Corporation. In that case, the employer did not hire the plaintiff after she told them that she had a medical marijuana card and that she was going to fail their drug test. So she then sued under both the medical marijuana law and the Rhode Island Civil Rights Act. Like in the Barbuto case, the Rhode Island law states that a qualifying patient cardholder cannot be denied, quote, any right or privilege for the medical use of marijuana, unquote. The court concluded that the employer violated the medical marijuana law by denying the plaintiff employment based on her use of medical marijuana. And in this case, the medical marijuana law also contains a provision that states, quote, nothing in this chapter shall be construed to require an employer to accommodate the medical use of marijuana in any workplace. And I emphasize the in, because based on that language, the court concluded that the General Assembly contemplated that the statute would in some way require employers to accommodate the medical use of marijuana outside the workplace. The employer in this case also argued that it refused to hire the plaintiff based on her inability to pass a drug test and not her disability, but as Parker mentioned earlier, the two are really sort of an intertwined concept, and it's not possible to distinguish the use of medical marijuana from the underlying disability, said the court. The employer also argued that the state medical marijuana law was preempted by federal law, but the court concluded that what employees do during non-work hours doesn't impose any responsibility on the employer. And therefore, what employers do with regard to employees off duty is not relevant. They don't violate federal law by employing someone who uses medical marijuana off premises. In this particular case, the employer has appealed the ruling, and we don't yet know what the court is going to do there. But we will keep you posted. And then finally, after that case came out, Connecticut jumped in with Nofsinger versus SSC Niantic Operating Company, LLC. In this case, the employer nursing facility rescinded the plaintiff's offer of employment after she tested positive for synthetic cannabis, which she was taking for medical reasons. The state medical marijuana law contains language prohibiting discrimination, including employment discrimination, against individuals for using medical marijuana. So this is one of those categories that Parker talked about earlier. The court rejected the employer's argument that the Federal Controlled Substances Act preempts this provision because the CSA doesn't regulate the employment relationship at all. It just deals with the use of drugs. The court also found that the ADA did not preempt the state law because the ADA only regulates drug use at the workplace, which permits an employee to use medical marijuana outside of the workplace. So again, inside, employers can control, outside, employers cannot. And in this case, the employer had also argued, this was a creative one, that the state law was preempted by the Food, Drug, and Cosmetics Act. And again, the court dismissed this argument because the FDCA does not regulate employment at all. So what we are seeing here is a new trend, looking at what the language of the state statutes say, as opposed to just relying on the federal law and marijuana use being illegal under federal law. So can you terminate an employee who tests positive because of medical use? Previously, as I said before, we would have said, go right ahead, no problem. You can terminate it because they are breaking federal law. But now with these recent cases, the law has become really unsettled. And so it's going to depend on what the language is in the state statute for your state. As Parker discussed earlier, does the language prohibit discrimination against medical marijuana users? Does it guarantee that users will not be denied any rights and privileges? And we have to look at what the courts in those jurisdictions have said. But as I mentioned earlier, courts change their minds, so it's important to stay on top of these developments. So what does this mean for employers? Back to the key takeaway. Employers in all 50 states can still regulate employees' use of marijuana in the workplace by prohibiting marijuana possession and use at work, and by prohibiting reporting to work impaired or under the influence of marijuana. But keep in mind, you may have to reasonably accommodate a medical marijuana user by excusing them from drug testing policy requirements that state that an employee will be terminated for testing positive for drug use. So how does this impact your workplace policies? And when employees come onto the company's premises, they become the employer's responsibility. And employee marijuana use that impacts an ability to do his or her job becomes a legitimate concern for the employer. Similar to alcohol use, companies have the right to prohibit employees from working under the influence of marijuana. So, Can you drug test for marijuana use? Absolutely. If they test positive for marijuana and they say they're a medical marijuana user, you can also require verification of that use. But what will be your stance on off-duty use that does not cause job impairment? So if there's no state medical marijuana statute, you can absolutely have a policy that states any employee will be terminated for testing positive for marijuana use. If you're a federal contractor or a DOT-covered employer, you could also have that policy. No drug use, period. If your state permits medical marijuana use, then you need to look at the statute and the court opinions to see if you have to excuse employees from meeting the drug testing requirement as a reasonable accommodation. You do not have to permit or accommodate recreational use, at least at this point. And you may also be able to establish a drug-free requirement for safety-sensitive positions. So let's talk about the practical complications involved with drug testing. Because at this point, testing for marijuana doesn't establish whether someone is currently under the influence, unlike alcohol testing. So, and I actually did a little research on this because I saw something that was a little confusing to me. There is testing that is done through urine, there's testing that's done through blood, and apparently marijuana testing does show up differently with those types of testing. So with urine testing, it looks at the metabolites in urine, and they can stay in urine for days, if not weeks. And blood testing, on the other hand, looks at a more immediate influence of the drug. So it looks at metabolites within the blood that could be there for anywhere between 4 to 24 hours. The problem is both of these tests are not sufficiently accurate to establish whether someone is currently under the influence. So if somebody had smoked marijuana the day before when they were off duty and then report to work, they may no longer be under the influence, but they will still test positive. So that's really problematic. It also depends on the person's body chemistry. It depends on the person, how much marijuana the person is smoking. It depends on whether the person is eating or smoking the marijuana. Those can all have an impact on how it shows up in the testing. In addition, unlike alcohol testing, where the higher you test, the more drunk you are, with marijuana testing, it doesn't necessarily reflect whether somebody is under the influence, even if they test very high. That they may not necessarily be impaired, because some people can have a very high THC test result and not be impaired, and other people may be very impaired with a very low THC test result. There are current efforts to develop tests to measure actual impairment, but so far those are just not very successful. So where does that leave you? Well, you can rely on other indicators. So certainly if somebody is in possession of a drug or paraphernalia, that would be an indicator. So what do I mean by paraphernalia? Pipes, shredded leafy debris, cigarette rolling papers, very small bottles of oil, small metal clips, and eyedroppers. And I'm really naive, Parker, because I have no idea what some of these things could be used for. I could probably check with my teenagers, but I think I'd just as well not know. Reports by others of use. So a coworker could report that one of their fellow employees was out smoking marijuana during a break or during lunch. You would have to weigh credibility issues under those circumstances. Would the person who's reporting have some sort of axe to grind? Are they trying to get the other person in trouble? Are they believable? Also, the smell of marijuana. That I think many people can recognize that. I certainly smell it a lot now when I walk down the streets of New York. It seems like everybody is smoking marijuana on those streets. But in addition to those kinds of indicators, there are also physical and behavioral indicators. So bloodshot eyes, fast heart rate, that might be a little hard to check. Sleepy, lethargic, lack of coordination, increased appetite, the munchies. Behavioral changes like confusion and lack of focus, memory impairment, or somebody who's unusually talkative. But you have to be careful because these aren't absolute indicators. These are just indicators. It would be wise to have multiple indicators. You know, if somebody is just talking very fast, That doesn't necessarily mean they're high. It could be that they've had a lot of coffee that day. I know that I certainly talk a lot faster when I've had my cup of coffee. And also, it is helpful to have multiple witnesses, so multiple supervisors or managers who have observed the same indicators. So we would suggest that you do review your policies to ensure that your restrictions concerning marijuana are consistent with the laws that apply to you in whichever states you're in. And that you also review your job descriptions to make clear which positions, maybe all of them, are safety sensitive positions. Now, I would kind of doubt that all positions could be arguably safety sensitive. Typically, you're talking about people who are working with machinery or drivers, not your administrative employees. That would be a really much more difficult argument to make. But that brings us to the end of our presentation. We have a little time here for questions if anybody has a question that they'd like to submit at this point. Or perhaps not. Perhaps we've just overwhelmed you with all the information that we shared. But certainly, if you do have any questions, you feel free to email either Parker or myself, and we'd be happy to respond to them.
Okay, with that, I believe that we can wrap up unless there's anything else you wanted to add, Fiona.